And we begin with this. A ruling on whether Judge Piet Koen should recuse himself from the controversial 1990s arms deal trial will be handed down in the High Court in Pietermaritzburg this morning. Last October, you'll remember that Koen asked both legal teams to make submissions on whether they believe he should no longer preside over the matter after considering the best interests of justice. Well, it comes just after former President Jacob Zuma instituted a private prosecution against News 24 journalist Karen Moore and the arms deal prosecutor Billy Downer, claiming that they unlawfully leaked his medical records. Well, let's speak now to our senior politics reporter, Ziyanda Ngcobo, live for us in Pietermaritzburg. Ziyanda, good morning to you. And this court hearing today, is it primarily about Judge Piet Koen's future over this trial?
Absolutely, Koli, and it could be a matter of asking the judge president in KwaZulu-Natal to reassign a new judge to this matter. However, earlier on we spoke to Mpumelelo Zikalala saying that it wouldn't necessarily cause any further delays to the start of trial because the actual merits of the matter will be dealt with during the trial, which is why then right now is the perfect moment to deal with any possible prejudice or unfairness towards or against former President Jacob Zuma and French arms company Thales. So I'll bring in Mpumelelo Zikalala again because one of the other issues I think that needs to be unpacked here is how these matters of the private prosecution and the arms deal trial, because we know that that private prosecution cascaded from this matter, and how the comments that Judge Piet Koen made, the comments that he made when he dismissed the special plea made by former President Jacob Zuma for Downer to remove himself have an implication and have led us to this moment.
It precisely deals with the innocence or guilt of the accused in this matter. So as a presiding officer, remember you're coming there with a blank slate. You hear the evidence that is there. You either accept it or you're going to dismiss the evidence. That's going to determine whether you deem the person innocent or guilty. Now, if you're going to make certain pronouncements, and those pronouncements cannot be interpreted by the receiving party as being biased. So you've already made your decision, whether how slightly or unlikely those particular comments are. The perception can be created that you've already decided the case without even hearing the basis of the evidence or the majority of the evidence. So on that basis, you are going to be biased. But it's a twofold type of application of matters that should be looked into. It's either from the side of the aggrieved party making that particular application, or from the side of the presiding officer saying that, you know, I'm so tainted, I've already made certain pronouncements on this particular matter, and this is my belief and the manner in which I'm thinking of which it must be alluded to through the presiding officers, because it's very likely where a person would admit and say, I'm going to be biased in this matter, there's a potential that in which I'm going to be biased. So let me recuse myself from this early stage so that I don't taint this matter. What am I looking for? I want to protect the rights of the accused in Section 35. Also, it must be in the interest of justice that I do this earlier on so that we don't find any problems as we move along the matter at a later stage.
How often does it happen when the recusal process is actually led by the judge themselves as opposed to it coming either from the state prosecutor or the defense?
It is very seldom, unless if the presiding officer will then say, you know, maybe you didn't know, but I have close connections with the individuals that is there, or this is my belief system. I do not believe that I'm not going to be biased in this particular matter, so I'm recusing myself from this matter because I can see that at a later stage, if certain information were to suffice, it would mean that my decision-making process was tainted. That is something which I don't want to happen in this particular matter. I want to protect the integrity of the justice system and this matter at all costs. So let me recuse myself before you even make the application as the applicant.
Does Judge Piet Koen need to actually declare what made him feel that his conscience is conflicted and that he may have to recuse himself? Or is it a matter of him throwing the ball back into the legal representatives court to say, you tell me what you think on the basis of my statements?
I think he has already tried to do that by saying, can you make submissions pertaining to my recusal application or consideration, let's call it that. Are there any submissions that you would like to make? Is there anything that you would like to bring to my attention? I have my own beliefs that I might have not shared at that particular point in stage. However, at a later stage I may be able to share. But he's not really obligated to state into the details or go deep into the details of why he wants to recuse himself. He can simply go to court and say, after considering this matter, I've taken a decision that I must recuse myself from it. I've made certain pronouncements in this matter that are going to be problematic at a later stage. On that basis, I'm not fit to sit as the presiding officer of this particular matter. I have already communicated with the Judge President of KZN, and arrangements are being made for another presiding officer to come in. So there's no need to go into the reasons of that element of biasness that has been perceived by Judge Koen, or that may be perceived by Judge Koen. It's simply just to pronounce on the issue, and then you're done.
Mpumelelo Zikalala is a legal expert, Xoli. So judgments to be handed down at around 10 o'clock this morning. We'll hear then whether or not Judge Piet Koen intends to remove himself from this trial.
Live for us at the Pietermaritzburg High Court. Thank you very much, Ngcobo, out there for us.